Hello and welcome to NTIQ TAP, helping you meet your CPD requirements. Welcome to this latest episode. This one is on the debt respite or the breathing space scheme, and in particular, it's regarding the guidance that's been issued to creditors for any debt that they might have that's been placed in a breathing space. So useful to see it from a creditor's point of view, and it's been issued by the Insolvency Service. So let's have a little look. So the first responsibility creditors would have is to stop action and apply the protections that the breathing space gives a debtor. So if a creditor is told that a debt owed to them is in a breathing space, a BS, they must stop all action related to that debt and apply the protections. And those must be kept in place until the breathing space ends. Unless they have permission from the court, a creditor or their agent must not do any of the following. So it mustn't take any enforcement action against the debtor or anyone who is jointly liable with them for a breathing space debt, mustn't contact the debtor to request repayment of the debt, and they mustn't take any step to recover that debt. As we know from previous webcasts on it, that's the protection that the breathing space gives the debtor, but obviously creditors might not have necessarily known that or known what to do. The Insolvency Service will notify a creditor about each debt owed to them that is in a breathing space and the date the breathing space started. A breathing space will start the day after the debtor's details are put onto the breathing space register. If the notification includes an end date, it's a standard breathing space. So the protection will be 60 days, as we know, after the breathing space is applied. If there's no end date, then it's a mental health crisis breathing space, or an MHCBS. It may be possible that the debt owed to the creditor is added to a breathing space later because it's only identified after the breathing space has started. Joint debts can be included in a breathing space even if only one person applicable enters a breathing space. And the joint debt will become a breathing space debt, and the protection applies to the other joint parties. A creditor can still charge the non-breathing space individual interest and fees, and the breathing space does not affect the other people's debts and liabilities in their own names because they're not in a breathing space. The next responsibility is to tell the court. So if the claim has already been issued, a court claim, or where enforcement proceedings have begun, the creditor must inform the court in writing of a breathing space having started. The creditor must tell the court about each debt that has entered a breathing space. The court will not check for other debts against the debtor's name. If the debtor has debts owed to the creditor at different courts, the creditor must notify each court. When informing the court, the creditor must do the following. So explain whether the debt is subject to a standard or a mental health crisis breathing space. Provide the date on which the breathing space started, where possible, and include a copy of the notification from the Insolvency Service where possible. Creditors can send notifications to the court by post or email. Okay, your next one is enforcement agents. So when the creditor has told the local court about the breathing space, the court will then tell any instructed county court bailiff to pause enforcement action. The creditor must inform any other enforcement agent they have instructed, and that includes High Court enforcement officers. If creditors don't do this as soon as possible, the creditor may be liable for any losses the debtor or the agent have as a result. If an arrest warrant has been issued in council tax proceedings, the creditor counsel must instruct the enforcement agent not to execute that warrant. If repayment plans have already been agreed, the debt advice provider will decide if the debtor can still afford to pay. Enforcement agents cannot enforce the writ or warrant until the breathing space ends. If the creditor applies to reissue a warrant or a writ of control during a breathing space, the court will refuse the request. What happens next? Well, court proceedings continue until an order or a judgment is made, except for enforcement actions such as evictions. In a breathing space, the court won't issue a money claim or process a help with fees application. They won't process a default judgment. They won't issue any form of enforcement application, such as a warrant, writ, or charging order. They won't continue with any form of enforcement application already issued, including evictions. And they won't proceed with a debt where a bankruptcy petition has started. The regulations, allow the court to correspond with a defendant during a breathing space where necessary. So only the court can correspond with the debtor, not the creditor. Any other application made by a debtor during a breathing space will be referred to a district judge to decide if it should continue or be adjourned. And then enforcement hearings. So for a standard breathing space, any scheduled hearing relating to the enforcement will be adjourned to no earlier than 14 days after the end of the breathing space. For a mental health crisis breathing space, any scheduled hearing cannot take place. This will be reviewed by a judge if adjourned beyond 6 months. With housing repossessions for standard breathing space, any scheduled eviction will be suspended to no earlier than 14 days after the end of the breathing space. If the debtor has applied to suspend the eviction, the application will be rescheduled after the end of the breathing space, but before the eviction. And for a mental health crisis breathing space, any scheduled eviction cannot take place. Again, that will be reviewed by a judge if suspended beyond 6 months. If the debtor has applied to suspend the eviction, as above, the application will be rescheduled after the end of the breathing space, but before the eviction. We've then got charging orders in the County Court Money Claims Centre, or the CCMCC. It's catchily titled. A creditor may have applied for a charging order, of course, to secure the debt against the debtor's home or property. The court may have then made an interim charging order, an ICO. For a debt in a standard breathing space, the CCMCC will defer any ICO. If there is time remaining for the creditor's notification of service or for the debtor to respond, the court will add this to the breathing space period. Following this, the ICO will be automatically referred to the judge or legal advisor to make a final charging order unless the creditor tells the court not to. When a mental health crisis breathing space ends, the court must allow the debtor any remaining time they have to make any objections to the ICO to the court. Following this period, the creditor should confirm in writing to the court when the mental health crisis breathing space ended and when the creditor wishes to proceed with making the ICO final. After 6 months, any ICO application where there's a mental health crisis breathing space still in place will be referred to a judge for a decision. When a breathing space ends, a creditor should inform the court when it ends. They should contact the court to tell them whether they wish to proceed with enforcement action and submit the relevant request to continue with it. Enforcement action can be restarted from the point it stopped, and there's no fee to do that. Okay, so thanks for joining me. Lovely to have you with us as ever. We'll look forward to seeing you very soon. Thanks for tuning in. We'll see you very soon on NTIQ TAP. Thanks very much. Bye-bye.